Hi, I'm Russ Wenninger. I'm a lawyer with Wenninger Jong. A question I sometimes get is, do you really need to do an enduring power of attorney and a personal directive when you do a will? When people book an appointment with a lawyer to do a will, it's common to do two additional documents aside from the will, the enduring power of attorney and the personal directive. The enduring power of attorney appoints one or more financial representatives to act if you become mentally incompetent, whereas the personal directive, it's similar, but it appoints representatives and it gives some instructions for those representatives to deal with medical and personal rather than financial decision making. The question is, do most people need those two additional documents, or is it okay just to do a will? In the vast majority of cases, I try to steer my clients towards doing all three documents. For starters, if you live long enough, it becomes more and more likely that you will eventually become mentally incompetent. A person who becomes mentally incompetent, either through a brain injury or through age-related mental decline, may still end up living for years. It becomes extremely beneficial to that person and to that person's loved ones to have documents in place that determine who has authority to make decisions for that person. If a person doesn't have an enduring power of attorney or a personal directive, family members may have to bring costly and legally complicated court applications to be appointed as representatives of the mentally incompetent person. One of the goals of doing a will is to allow for smooth and cost-effective transfer of an estate to beneficiaries. However, if you don't have an enduring power of attorney and a personal directive, and family members have to pursue additional legal remedies in order to make decisions for you, that will deplete your estate to some degree and deprive your beneficiaries of what they might otherwise expect to receive. Also, you never know who will apply to a court to be appointed as a representative. If you prepare an enduring power of attorney and a personal directive, you're the one determining who will represent you in the future. Finally, you'll likely want to prepare those documents at some point anyways. And if you do them when you do your will, you'll likely save on legal fees by getting the documents bundled together. It's definitely more efficient to complete all of those basic estate planning documents at one time rather than doing them separately. So yes, you should almost certainly do the enduring power of attorney and personal directive at the same time that you do your will. If you have any questions or comments, feel free to leave them in the comment section. Thank you for watching.